Two.
Good morning. This is the matter of Pamela Moses versus Mark Goins, Trey Haggard. Good morning. Jonathan Scametti. Dr. I'm getting a little feedback. Hold on 1 second. Can we correct that, please?
Yeah, so if anybody's watching the YouTube live stream, please close off the web page.
Okay, let's try that again. Good morning, everyone. This is the matter of Pamela Moses versus Mark Goins, Trey Haggard, Jonathan Scametti, docket number CT-1579-19. And we are here this morning. We have 3 motions to quash that have been filed by the defendants. And before we get started, let's go around and identify who's present. And we'll start with Mrs. Moses's attorneys, Mr. Harbenreich. So if the 3 attorneys could please identify yourselves, and then the attorneys for the defendants, please identify yourselves.
Good morning, Your Honor. This is John Harbenreich on behalf of plaintiff Pamela Moses.
Okay.
Good morning, Your Honor. This is Matthew Peterson on behalf of the plaintiff.
All right, good morning.
Good morning, Your Honor. Seth Engel on behalf of the plaintiff, Ms. Moses.
All right, good morning. And then for the defendants.
Good morning, Your Honor. Robert Wilson of the Tennessee Attorney General's Office here on behalf of the defendants and non-party Office of Legal Services.
Okay, good morning. And then it looks like we have 3 other parties or people present. Marvin Williams. Could you please identify yourself?
Yes, ma'am. I'm currently the paralegal for the 3-judge panel, and I'm sitting in for Danielle as the coordinator.
Okay, that's Mr. Williamson. Okay, your full name didn't appear, so okay, very good. And then we have a Duncan Bryant. Mr. Bryant?
Yes, good morning. Duncan Bryant with the AOC.
Okay, good morning. And then we have a Liam McCullough. Yes, good morning, sir.
Good morning. Good morning, Your Honor. I'm a reporter covering this hearing.
Okay. Are the reporters live? Are they supposed to live stream, or are they supposed to be part of the panel here? Just need clarification on that.
Yes, ma'am. So it's up to you if you want to keep Liam on the live stream under the Zoom call. So it's up to you on that decision.
Okay. Do we have any other reporters or media present?
No, ma'am. It's just Liam on the call.
Okay. All right. And then we have 1 person calling in from a 615.
And that's also Liam, just in case that his Zoom video does, disrupts.
Okay.
Yes,
well, normally we have, of course, everything that we do is transparent, and we want the public to have access to, to this hearing and all that we do. Normally, the media would just view the hearing on stream, as does the public. But since we have him present at this time, not to cause any further delay, we'll let him participate in this way. But perhaps next time, if he could just view the hearing on the live stream, as does everyone else, that would be the preferred method. But I don't see any problem with that. Let me just confer with my colleagues, Judge Tidwell and Judge Cook, to see if they're in agreement.
Your Honor, Robert Wilson, just for clarification, I believe Liam is the court reporter, not a media reporter.
Oh, he's a court reporter. Okay, I'm sorry, I misunderstood. Okay, well, that makes a big difference. So he's a court reporter, Mr. Liam?
Yes, Your Honor. I should have clarified that.
Oh,
I'm with Veritext.
okay. Okay, that makes a big difference then. Okay.
It does. And to be fair, I interpreted you as being a reporter with the media too. So I went the wrong direction on that too.
I also interpreted that as a reporter from the media.
Okay. All right. Well, thank you for clarifying. All right. Well, if there's nothing further, then I think we're ready to get started this morning. Are the parties ready?
Yes, Your Honor.
Plaintiff is ready, Your Honor. And I will just say on the two different motions, I'm with the court's leave. I'll be arguing one of the motions and Mr. Peterson will be arguing the other for the plaintiff.
Okay, that's fine. All right. Well, Mr. Wilson, if you're ready, which one would you like to take up first?
Your Honor, if it's okay, I would like to take up the defendant's motions to quash first.
Okay. And which one is that? Because we have two. Actually, we have the defendants. Okay.
That'll be the defendant's motions to quash the subpoena directed to non-party Office of Legal Services and then also to non-party the Tennessee Department of Correction.
Okay.
One was filed on January 2nd of 2024, which is the one to the Office of Legal Services, and then on December 11th, which is the one to the Tennessee Department of Correction.
Okay. Which one do you want to take up first?
Your Honor, since they both argue the same, I don't think it necessarily matters which one.
Okay, that'll be fine. You go right ahead.
Okay, thank you, Your Honor. And again, just to reintroduce myself, Robert Wilson, on behalf of the Tennessee Attorney General's Office, on behalf of the defendants for their motions to quash and for a protective order. That's a little bit of background for this court's convenience. This court conducted a case management conference on October 5th, where plaintiff Pamela Moses made an oral motion to propound additional discovery. This court on October 11th entered an order that granted her oral motion and limited discovery to 3 topics, which involved race and ethnicity in conviction data, voting pattern data, and also for legislative history of the 1986 and 2006 challenge statutes. The order gave Ms. Moses 30 days to propound her discovery and also provided that the defendants were to respond to the discovery request within 30 days thereafter. The purpose of the defendant's motions in this case, motions to quash and for protective order, as to Ms. Moses' subpoenas to non-parties, TDOC, the Tennessee Department of Correction served on November 21st, and the Office of Legal Services served on December 12th, is that this court's October 11th order did not allow her to serve third-party discovery requests, and even if it could be construed as allowing her to serve third-party discovery requests, she did so after the deadline of the 30 days that were allowed in the order. And first taking up the order itself, nothing in the October 11th order authorized her to serve third-party discovery requests. Again, it only provided that she could propound discovery on limited topics, 3 limited topics, and that defendants were required to serve their responses to those discovery requests 30 days thereafter. All other deadlines in this case expired. There's no other discovery requests deadline that could be applied in this case. The only other deadlines were from the court's original September 2022 scheduling order, and all of those deadlines involving written discovery ended in January of 2023. Of course, even if the order could be construed in a way that allowed third-party discovery requests, the plaintiff clearly didn't serve her subpoenas in time on the third parties. So at the court's October 11th order provided that she was to propound her discovery request within 30 days of its entry, which was on October 11th. So that gave her until November 10th to serve her discovery requests. But she didn't serve either non-party Tennessee Department of Correction or non-party Office of Legal Services within that time period. Instead, she served the Department of Correction on November 21st, and then also the Office of Legal Services again on December 12th. And as we noted in our brief, and plaintiff doesn't appear to dispute, third-party subpoenas in Tennessee are discovery devices. We cited cases that refer to third-party discovery requests as discovery devices. And then applying a substantially similar rule in federal district courts have held that subpoenas are subject to discovery deadlines. And there's no reason in this case to allow plaintiff to serve third-party discovery requests after any of the deadlines. And in any event, even if this court did find that she should be permitted to reopen discovery and serve her discovery requests after the discovery cutoff in the October 11th order, her subpoenas need to be substantially altered. She seeks a lot of documents that are not authorized by the October 11th order. And that includes all documents for legislation passed from 1972 to 2011, all communications with persons ineligible to vote because of a felony conviction. And I would remind the court that plaintiff's challenges are to persons or to statutes that govern what we've tagged as permanent disenfranchisement, not disenfranchisement generally. And then also as to other parts of TDOC, she seeks documents regarding persons that have been supervised by the Department of Corrections since 1981. That includes, information on their child support obligations, their court costs, gender, supervising agents. And then again, all documents of convicted people of an infamous crime, including people that would be eligible to seek restoration of the right to vote, or people that are ineligible by the challenge statutes here. And plaintiff has also, in her response, raised an issue as to defendant standing to file a motion to quash. We've cited to several federal district court cases that have either found that defendants have standing to enforce court's order discovery deadlines, either through a motion to quash or a motion for protective order, which defendants have filed here. And in any event, the standing issue isn't dispositive because this court has the inherent authority to quash an untimely subpoena. But for those reasons, we request that this court grant defendants' motions to quash for a protective order.
All right, thank you, Mr. Wilson. Mr. Harborick, who's going to argue the motions for the defendant?
It will be myself, Your Honor.
Okay, you go right ahead.
Your Honor, I need to give a little bit more context to how we got to where we are here, because I think it will be helpful to resolution of this issue. Originally, back in December of 2022, we sent our initial discovery requests to the defendants, seeking much of this kind of data, particularly the race and ethnicity data, along with a variety of other things. Into early 2023, if the panel will recall, and this is, I think, before Judge Cook's time on the panel, we litigated a motion to stay discovery. That motion was denied, and so we went forward in the discovery process. We received written responses and some documents, but we also received a lot of objections. And so in the March and April timeframe of last year, we had a meet and confer call between myself and opposing counsel. I had a follow-up email, followed up 4 to 5 times in April of last year. Finally reached an agreement on a protective order so we could get some additional documents we needed. That wasn't filed until May. We didn't get supplemental documents from the defendants until late June of last year. And then in July, we got the order on the motion to dismiss. Shortly thereafter, we got the motion for interlocutory appeal and to revise, and we were litigating that into the fall. In the meantime, we were trying to figure out, and we were very transparent with defendants, and I've said this before and it's in our papers, this is the kind of data we need. We need voting data, we need race and ethnicity data. And in fact, I was looking back at my email this morning, and the night before we had our status conference on October 5th, I emailed Mr. Wilson to say, here's my proposed scheduling order, because if we recall, the purpose of that October 5th hearing was to try to set a new schedule. In the end, we decided we need to deal with the motion to revise and for interlocutory appeal first. So we still don't have a scheduling order. Mr. Wilson and I were talking about scheduling orders, and I said, I think we need to build in some additional time to finish up written discovery because we're still missing this data that we need. And we know our experts have to have this voting data and they have to have this race and ethnicity data. And I said in that email, we think we can get this from you all, but maybe we need to get it via third-party subpoena. And it was not clear at that time. And I said in the hearing before your honors, when we started discussing this oral motion for supplemental discovery requests, here's the kind of data that we need. This is what our experts are telling us. We don't have a scheduling order in place right now. And so we think, extending a bit of time to make sure we can get this data that we need. We know that TDOC has it. We think that means the defendants have custody and control over it. It's sort of, they are part and parcel of each other, right? The defendants are the defendants, but they're also part of a larger state apparatus. It was our position at the time, frankly still is, they could have gotten this data for us. Nevertheless, we engaged in meet and confer process. We continued to. And so after that hearing, the court put down its October 11th order. November 3rd, we had a telephonic meet and confer where I raised these issues and said, are you all going to produce this data? We looked at your documents. It seems like you have it. It was unclear what was happening. So we went and sent our supplemental discovery requests, as the order led us, to the defendants. But nevertheless, during that month of November, it became clear that defendants were taking the position that despite the fact that this data existed, that TDOC had it, that the Secretary of State had it, that they were not going to produce it. And so therefore we said, okay, we're going to have to issue subpoenas to get this, it looks like, rather than trying to get it through the supplemental discovery requests, through the meet and confer process. And so that's what we did. We still are taking the position, and we're still in active conversations with opposing counsel around supplementing their discovery responses. In fact, we came to an agreement on getting a lot of this voting data after the last status conference. And we're still waiting on that. We still haven't gotten the voting data sitting here today. And so despite the agreed order being entered. And so from our perspective, we're playing a game of whack-a-mole, and it's taking months and months and months to get some very basic things that we need. And as we put in our briefing, I wish we had a court reporter here. That's an oversight on my part or defendants or whoever. My recollection of the hearing was I made an oral motion to do supplemental discovery requests to the defendants, because I think the panel was of the opinion that despite the fact that we didn't have a scheduling order in place at the time, the prior discovery cutoff for party discovery had been back earlier that spring, and I had served discovery. And so I needed to, if I thought I needed more discovery, plaintiff needed more discovery, I needed to ask for it. So I made that supplemental discovery request, but there was discussion of subpoenas at that hearing. And I was very candid. I said the same thing to the panel that I said to Mr. Wilson via email, which was, I'm not clear on who has this data, whether I can get it from defendants or they're going to take the position that I need to go elsewhere. I'm not sure. And so I may need to issue third-party subpoenas. And I think that was very clear in front of everybody that that was going to be an option, because there was no provision in either the prior scheduling order for third-party subpoenas. It doesn't mention subpoenas. There's no reference to third-party subpoenas in that October 11th order. It's very clearly focused on supplemental discovery requests to the defendants. It says the defendants have 30 days to respond to these. And so we went forward trying to get whatever we could from the defendants, belt and suspenders. We went ahead and sent our subpoenas. The reason why the standing argument is sort of tied into this is because the Office of Legal Services and TDOC have not filed motions to quash on these are too broad or we don't have these documents or whatever. Office of Legal Services has its motion to quash on the legislative privilege issue. But TDOC, and this is critical, has not filed a motion to quash and has not said this will prevent, this is prejudicial or cause some sort of undue burden to us. All we have is the defendants trying to interject themselves into the dispute here and say, well, I know that that order doesn't say anything about subpoenas or third-party discovery, but we think really this was a final discovery cutoff. And frankly, Your Honor, we are we are playing this game where we're told we have this data. No, go over here to get this data. No, you can't get it from them. Go over here to get this data. No, you need to go over here. You need to ask them. We don't have it. Ask them. It's frankly a little frustrating. We are trying to get some very simple, basic stuff around intent, around race and ethnicity data, around voting data. And the bottom line, as we put in our briefing, is this stuff exists. We know it exists. TDOC produced it in another case. They can just make us a copy of what they produced then. We know the voting data exists. The defendants have said they're going to give it to us. We know some of this legislative history stuff exists. We're trying to run around our tail to try to get a hold of this stuff. But this whole motion to quash, particularly this one on this timing and all of this is just, if I may say, feels like gamesmanship. We are simply trying to get a couple of categories of data that the state has, that we know that they have. And rather than just being straightforward and saying, all right, here it is, let's do the rest of the case, we're now 6 months into this fight or more, trying to get some basic stuff, and we still haven't gotten it. And you'll hear when we talk about the scheduling order, that's part of the problem. We can't accelerate this case. Our experts can't do their report. We can't finish this initial discovery phase until we get this basic stuff. And that's been clear from the beginning of the case. We talked about statistical proof in our amended complaint and in our response to the motion to dismiss. That's what we're trying to get. And so that is the broader context here. On the legal side of things, again, there's no provision in either the original scheduling order or the October 11th order that says anything about subpoenas or third-party discovery. As your honors, I'm sure, are well aware, sometimes once you do the party discovery process, and I've had rulings to this effect, you do the party discovery process. If you can't get what you need from party discovery, sometimes you have to do additional third-party subpoenas to follow up and get whatever documents you need. If you ask for financial information from the defendant and they say I don't have it, okay, fine, maybe I need to go subpoena the bank instead. That's how discovery goes. There is no applicable cutoff here. And frankly, the issue around standing, it matters here because the actual parties that are going to be producing this data have not filed this kind of challenge. And in fact, by separating themselves from these other state agencies, defendants have said, we don't have this. You're going to have to go get it from someone else. If they have taken that position that they are separate from all these other state agencies, they can't get the data, then they have to live with that position. They cannot then come in on behalf of these other state agencies and take a position objecting these subpoenas. If TDOC is separate and by itself, TDOC, they can object to our subpoena and we can talk about breadth and we can negotiate with them. OLS has objected on this narrow legislative privilege issue. We'll take that up. But if they're separate, then they're separate, and we will deal with them as is appropriate. But what is not appropriate is for defendants to try to continue to block us access to this very basic information. And so we think for those reasons, these subpoenas are entirely appropriate. We sent them as soon as it became clear to us during the meet and confer process that we were not going to get this information from defendants. And so we sent them, and we were in active negotiations with TDOC about the scope and search terms and all the rest of that until they said, look, we can't do this anymore because we have to wait on a resolution of the motion to quash that defendants filed. So this is putting us in a position of effectively the defendants are trying to block us from getting the very basic information we need to proceed forward in this case. And they're doing it in a way that is lengthening this case out unduly. What we need to do, plaintiffs would submit, let these subpoenas play out, give us some time in the scheduling order to resolve any subpoena issues that we may have with production and search terms. Let us resolve the supplemental discovery and our outstanding issues with the defendants. And let's get this thing moving and we can move into expert discovery and depositions. But there is just no basis here to quash these subpoenas as being untimely or to believe that there's some sort of hard deadline that we somehow missed. The October 11th order doesn't apply, and neither and this will be my last note here, neither do the restrictions on the categories of data. The October 11th order says you can submit supplemental discovery requests on these couple of topics. That was a limit that this panel imposed on our supplemental discovery requests to the defendants. And we may have a dispute about that gets raised via motion to compel or objection, or I'm not sure. But those narrow limits don't apply to third-party subpoenas because that order wasn't about the third-party subpoenas. It was about supplemental discovery to the defendants, which is what the motion was, which is what the order says. Third-party subpoenas are just outside that process. And for those reasons, we think a defendant's motion should be denied. Thank you.
All right, thank you, Mr. Harbin-Rick. Any questions, judges, before Mr. Wilson makes a reply?
I don't have any.
Okay, Mr. Wilson, your reply?
Yes, Your Honor, just a couple of points. The notion that Ms. Moses can sue one state official and that requires that state official to go to every other state agency has no authority whatsoever in Tennessee law, and we object fully to that. We'll be happy to brief that issue if the court deems it necessary. Second, we didn't hear anything from Ms. Moses that she couldn't have filed or served her subpoenas within the October 11th order's deadlines, or that she couldn't have moved for additional time to serve her subpoenas. Again, there's no order out there, either in the original September 2022 scheduling order or in this court's October 11th order, that permitted her to serve third-party discovery after the discovery cutoff. She doesn't dispute any of the cases that we've cited to, saying that third-party discovery is also subject to discovery deadlines in this case. And Ms. Moses also noted that TDOC has not filed a motion to quash yet. But if you look at page 2, footnote 2, it says that she's been in discussion with counsel for TDOC regarding her subpoena request, and that they've taken the position that they're not going to produce anything until the motions to quash are resolved. So the idea that TDOC isn't objecting at all just isn't borne by the record or through her own arguments. And again, Your Honor, Ms. Moses has accused the defendants here of playing gamesmanship, but we'll note, as we do in our reply, that she herself has objected to defendants' discovery requests on timeliness grounds, and those were served with mere days after this court's order denying the motion to stay, defendant's motion to stay, that Ms. Moses also opposed. And in that order, this court said that the parties had agreed to aggressive scheduling deadlines. And then Ms. Moses is now asking for permission to not have those deadlines apply to her. And so for those reasons, we ask that the court grant defendants motions to quash it for a protective order.
All right, thank you, Mr. Wilson. As I'm listening to the arguments, I'm going back in my mind trying to recollect parts of the hearing. I don't think a court reporter was present. I'm not sure if we recorded it on Zoom, but I do remember there being discussion regarding a distinction between subpoenas and written discovery. And of course, we prepared the order, which I have in front of me, dated October 11th, 2023. And it says plaintiff has 30 days from the entry of this order to propound discovery limited to the following topics: race, ethnicity, and conviction data, voting pattern data, and the legislative history of the 1986 and 2006 versions of the challenged felon disenfranchisement statute. And then of course it says defendants are given an additional 30 days to respond to the discovery request. Now, as I recall, and correct me if I'm remembering this incorrectly, but this order was only intended to apply to written discovery. It did not include depositions because, of course, the written discovery would need to be completed, and the plaintiff would need to receive the discovery that was anticipated in this order before any depositions could be taken. So I don't think that this order, although it says order to propound discovery, contemplated that it covered depositions or subpoenas. It's my recollection that it was only intended to cover the written discovery that defendants would need to respond to, and within what time frame they would need to do that. But that's my recollection. I don't know if Judge Tidwell or Judge Cook may recall that specific hearing, but it just doesn't make sense that, and of course, our orders speak for themselves, but it doesn't say written discovery, it doesn't say all discovery, it says propound discovery. And if it was not anticipated to cover depositions, which could not be taken until after written discovery was at least maybe not necessarily completed, but some of this data was provided, then why should we read the order as including subpoenas as well? So that's just a question. Mr. Harbinrick, you look like you wanted to say something.
No, Your Honor. I think it's important to note, as you read out, that the last line before it is so ordered is defendants are given an additional 30 days to respond to the discovery request. To our mind, that encapsulates the panel speaking through its orders. This order is specifically about supplemental discovery requests to the defendants. It does not somehow then convert itself into a broad discovery cutoff, which is what I think Your Honor was talking about. It by its terms does not address subpoenas. And so my recollection is in accord with Your Honor's, in that this was a narrow order on a narrow oral motion for additional supplemental discovery to the defendants.
Okay, Mr. Wilson, was this order intended to cover all discovery? So would that include depositions as well?
No, Your Honor. I think it was limited to written discovery as well. But again, Tennessee courts, and plaintiff hasn't disputed, consider subpoenas seeking discovery from third parties to be discovery devices. And as we've noted, several federal court decisions have also determined that discovery devices, including third-party subpoenas, are subject to discovery deadlines. So even if this order, the October 11th order, didn't anticipate subpoenas, then we would go back to the original September 2022 scheduling order. And we'd also note as well that this order didn't contemplate, expert disclosures or depositions as well. So this was based on plaintiff's oral motion at the October 5th case management conference, asking to propound additional discovery and including third-party subpoenas if necessary. And what this court, the order that the court entered, was only for discovery propounded on defendants. But even if it could be construed as an order including third-party subpoenas, plaintiffs still here didn't file or serve for subpoenas on the non-parties within the discovery deadline, whether that's from this October 11th order or in the court's original September 2022 scheduling order.
Right. Well, if the court was focused on, in the panel, when I say the court, if the court was focused on discovery between the plaintiff and the defendants and allowing additional time for plaintiff to discover certain data and information from the defendants, and the court remembers there being a discussion distinguishing between subpoenas. Well, if certain data is not available from the defendants, then the plaintiff would have the option of issuing subpoenas. So if that discussion occurred and we did not specifically address that in the order, why would it be prejudicial to the defendants in this case to allow, or would it be prejudicial, I should say, to the defendants to allow plaintiff an opportunity to discover this data from the Department of Corrections and the Office of Legal Services?
It would.
Well, my question was, would it be prejudicial to the defendants, or would it be prejudicial to the plaintiffs not to allow them to discover this information?
It would be prejudicial to the defendants, Your Honor, because these parties agreed to the discovery deadlines. Again, I'll note this in this court's order denying defendants' motion to stay discovery while their motion to dismiss was pending, in which plaintiff Ms. Moses herself opposed. This court noted that the parties had agreed to aggressive scheduling deadlines, including aggressive discovery. If the plaintiff didn't like the answers that she received from defendants regarding this, the discovery responses from the October 11th order, she could have moved for additional time to serve discovery. And again, we'll note that Tennessee courts consider third-party discovery to be discovery devices. And again, those should be subject to the discovery cutoff deadlines as well.
Okay. Mr. Harbenreich?
I think the only thing I'd like to point out, Your Honor, here is that defendants appear to be taking the position that if the October 11th order doesn't apply to subpoenas, which I don't think it doesn't by its terms, then we were obligated to issue subpoenas for this consistent with the prior discovery order, which again was not in effect as of October. We had already gone past our trial deadline. Trial had been taken off the calendar. We had both filed 2 agreed motions to amend the scheduling order. There was no operative scheduling order. But if you want to say that that prior scheduling order governed, then we would have had to issue these subpoenas by January 6th of last year. How could we possibly have known at January 6th of the prior year that defendants would be taking the position that they didn't have much of this data or some of this data? There was no way we could have met that deadline to issue subpoenas, which is what defendants are saying. If this October 11th order doesn't govern, then the prior scheduling order that was out of date somehow governs. That doesn't make any sense. That means we would have had to issue these third-party subpoenas. We would have had to know at the time defendants were taking this position that we can't get the data from them despite their documents showing that they have it back 10 months ago, and would have had to have, our deadline to issue subpoenas passed in January of 2023. That position doesn't make any sense either. The bottom line is that unless the scheduling order says specifically you have this deadline to issue subpoenas, generally speaking, you can issue third-party subpoenas to get information that you can't get or are unable to get from defendants. That's been our position the whole time. Third-party subpoenas are available to us to use. There is no prejudice to defendants, to us going to a third party to get documents from them. It doesn't slow down their process. It doesn't put an additional burden on them to do anything. That's why it's third-party discovery. If the third parties want to object, they can. But again, it doesn't cause any prejudice to defendants. It would cause extreme prejudice to plaintiffs not to be able to get this data. So again, these subpoenas are outside this sort of discussion we've been having about discovery requests to the defendants, supplemental discovery to the defendants. That's a whole party discovery discussion. Third-party subpoenas are not, they're separate from that. And to artificially try to impose these deadlines where no deadline has ever said anything about subpoenas, and in fact, they were discussed in depth during the October hearing, we think is just an attempt to block us from getting the data that we need.
So going forward, it sounds to me like we need to put a scheduling order down that says when discovery of all types, any type, whether it be written or oral, is concluded. Regardless of what is going to be ruled upon today, what it sounds to me is that to keep control of the case moving forward with a looming trial date a year from now, which is not that long in this type of case, it sounds to me like we, the judges, need to put down a hard and fast, after today, this is your date. Whether it's depositions, subpoenas, interrogatories, requests for production, requests for admission, etc. This is your day, right?
I would agree fully, Judge Cook.
Going forward, right?
Would fully agree, Judge Cook. Yes.
Mr. Hobbenreich, let me ask you, why should we have to do that? If the case law says subpoenas are anticipated within discovery, why should we have to put an order down like that? I mean, shouldn't we be bound, as well as the parties, by case law, that if we have an order that says here's the discovery deadline to be propounded, that it would include subpoenas? Do you, is your position that subpoenas are not included in propounding discovery?
It is my position that subpoenas are not included within propounding discovery within the terms of this scheduling order. The original scheduling order says discovery shall be propounded by January 6th, 2023, and then goes on from there. That at the time, perhaps we should have been more specific, but Rule 45 is third-party subpoenas. It is governed by the case law regarding breadth and overbreadth and objections and all of those sort of Rule 26, powers of the court to enforce sort of the outer limits of what's discoverable. So in that way, the case law applies. But definitionally, party discovery and third-party discovery are two different things. And so while there are many, many cases calling Rule 45 subpoenas, quote unquote, discovery for purposes of, objections and motions to compel and those kinds of things, it's the same case law. Categorically, they are two different things. And our position is, given the context before the court, given the timing, and given the expiration of the prior scheduling order, we didn't have a trial. The prior scheduling order set trial for September 21st, 2023. So by the time we were in front of the panel, that deadline was gone. And what we had moved was to set a new scheduling order. And at that hearing, we said we need more time to get this data. We don't believe that prior sort of broad deadline for discovery shall be propounded applies to third-party subpoenas, unless that it said third-party subpoenas. I have had many scheduling orders, as I'm sure Your Honor has too, that set specific deadlines for, at least 2 months before trial, any final sort of subpoenas need to be issued versus party discovery. But I don't think it is equitable or fair or correct reading of the original scheduling order in this case that had expired by the time we were starting to have this discussion to say that January 6, 2023 deadline was actually our deadline to issue subpoenas.
If I may, I'm sorry, Judge Tidwell, go ahead, sorry.
If that's the case, and that was the operative scheduling order, then couldn't you serve subpoenas a week before trial and say, well, it was never in a scheduling order, so therefore we're allowed to serve this and get the answers? I mean, I guess my question is, where does it end?
I think to Judge Cook's point, I think typically I have a scheduling order. I have used scheduling orders that have deadlines for that. Usually it's 2 months for trial or so. But in this case, our position would be, absent them being addressed in the scheduling order, we have a reasonable amount of time to issue third-party subpoenas. If we tried to issue a third-party subpoena 2 weeks before trial, I suspect we would very quickly get a motion to quash, or we would get, something, or the court would just decline to issue it. But again, absent a deadline for actual third-party subpoenas, I do believe we have some leeway to issue those, because you run into these problems where you can't get the information that you need from the parties. And so after you engage in this meet and confer process and all this other stuff, you sometimes have to issue third-party subpoenas and get the information that way, which is exactly what we're trying to do here.
I'm sorry. Go ahead, Judge Gordon-Johnson.
I was just going to say, Judge, I just have one other question. Mr. Wilson, did your office put the plaintiff on notice that there were certain data or documents that you were not going to provide pursuant to this October 11th order? And if so, when?
Your Honor, I don't have the specific date, but we did respond to the requests and say whether they were in our possession or not. And then we've also had discussion related to the October order about the voting pattern data. And of course, this court entered the agreed protective order. And so I'll be in discussions with my clients about when that's going to be produced. But again, the order here granted plaintiff 30 days, even if that can govern third-party subpoenas. She hasn't said why she couldn't serve her subpoenas within that 30-day time frame. It's not as if she was unaware of documents that the Department of Correction produced. Since at least September 2022, she notes in her proposed second amended complaint about the pending case where TDOC, the Department of Correction, produced this information in the Tennessee Conference of the NAACP versus Lee case that's pending in the Middle District of Tennessee. And she's noted it throughout her briefing as well. We'll also note she filed the expert report that was filed in that case a day before this court's October 11th where it came out. And there was even back in February of 2023, an expert affidavit that relied on a lot of the data that she's seeking to obtain from TDOC. Again, there's no plaintiff here hasn't shown any reason why she couldn't have served her subpoenas within any of the discovery deadlines in this case.
Well, what we're trying to decide is whether there was a deadline or whether this deadline contemplated subpoenas. But I think, and this is just how Circuit 1 has approached discovery, but we don't tell parties how to discover their case. And it's not uncommon for plaintiffs or defendants to seek discovery from the other side because it's generally more timely and more cost efficient. Issuing subpoenas usually comes with a cost. So the fact that the plaintiff could have issued subpoenas to the Tennessee Department of Corrections, yes, of course. But the fact that plaintiff has sought to discover that information from the defendants, that is totally proper to do that. And that is what was contemplated when we had the hearing, which resulted in the October 11th order. So the defendants were on notice that plaintiff was seeking this data. And the order was entered on November 11th of 2023. So if sometime after October 11th of 23, the defendants, through your office, notified plaintiff and plaintiff's counsel that certain data was not going to be available or that the defendants were not going to produce this, then why should the plaintiff not have an opportunity to then discover that data and information from a third party? So that's why I asked, what was the date, if any, that the plaintiff was put on notice? And then shouldn't plaintiff have a reasonable time from being put on notice to create that subpoena and to serve that subpoena? Because the defendants were on notice in November, I keep saying November, but in October, when we had this long hearing, and again, it was on an oral motion, so we don't have a written motion that we can go back and look at. We don't have a formal response that we can go back and look at in terms of an opposition. But this was clearly discussed during that hearing. If the defendants were going to take the position that we're not going to produce this data, and that if you sue one department, it's not incumbent upon that department within state government to go to another department or agency within state government to get documents. So if that's the position that the defendants are taking now, why did the defendants not take that position in the hearing from October 11th? And we could have entered an order that would have given plaintiffs sufficient time to discover whatever documents they would be able to discover from defendants, but then also have the ability to get this data and documents from third parties. So I'm a little bit confused by the prejudice to the defendants at this time. The only prejudice that I'm really hearing is that they did not issue the subpoena within this time frame. But again, the court is not certain whether or not the order contemplated a subpoena deadline.
Your Honor, just on the timing issue.
Yeah.
So October 11th was the order. We issued our supplemental discovery request to the defendants on November 8th.
So that was
originally
within 30 days. That was
within 30 days.
Okay.
That's correct, Your Honor.
Okay.
I originally attempted to issue the TDOC subpoena the same day because of some meet and confer discussions we'd had on the phone a few days prior, and it sounded like we were not going to get this stuff from defendants. So I actually tried to issue the subpoena on the 8th. I messed up the payment thing. I just didn't do it correctly. And so found out from the clerk about a week later that I hadn't issued it. I thought I had. So it went ahead and reissued the TDOC subpoena on the 20th. This is before we've gotten our responses to our supplemental discovery.
Okay.
On December 8th, we got our responses to the supplemental discovery request from the defendants. Those responses and the prior meet and confers we've had, because we sent a deficiency letter back in November, and we had a phone call meet and confer on December 7th, the day before we got our written responses. Based on the written responses and our meet and confer on the 7th and our prior discussions, that same day, December 8th, the day we got those responses, given everything we've been told, that's when we issued the subpoena, the second subpoena to the Office of Legal Services. So this all came very naturally as a result of ongoing discussions. We sent the supplemental discovery, we had follow-up meet and confer discussions, we sent a deficiency letter, and during that process, and then it was confirmed the day that we got our written responses to our supplemental discovery request, it was confirmed, we're not going to get this from the defendants. And so during that whole process, we issued first the TDOC subpoena, and then the day we got those written responses, we went in to issue the second OLS subpoena. It is, all of that was part and parcel to this whole discussion. We thought we were going to get this data from defendants. We assumed they could either get it or they would produce it. They had produced it in other cases. We know the Secretary of State has this voting data. They've now belatedly said, yes, we're going to produce the voting data, although we had to fight for months to get that. We assumed we were going to get this from defendants. Once it became clear that we weren't, we issued subpoenas. That is how the timeline went down. And so now we're just trying to get what we need via subpoena, given that we're not going to get it from defendants.
All right, thank you. I think Judge Cook has a question.
I think back during that hearing, again, it was an oral motion. I think that even during that hearing, we had said we don't have a motion in front of us addressing this, so it was all oral, but we heard it. But I recall at that time that you were arguing that the plaintiff wanted a longer time frame in the scheduling order to deal with motions to compel and or issuing subpoenas. Now, I don't recall whether that meant that the order that was entered was going to put the deadline upon y'all to issue subpoenas within the same time frame or not. But I do remember that you said on behalf of your client, you wanted a longer time frame in the scheduling order to deal with motions to compel and or issue subpoenas. Okay, so how to interpret what that meant now, I guess is why we're having this hearing. Okay, but just to cover all sides of it, the order says, quote, to propound discovery. Obviously, that's you serve something on somebody, you write something, you send it back and forth. And a subpoena is one of those forms of propounding discovery. Granted, it will be on witnesses or non-parties, but it is that. And I think maybe back during the oral motion and hearing that maybe I had said at the time, nothing has prevented the plaintiff from issuing subpoenas on any of these topics. In other words, at that time, it was we want more time to do discovery between the parties because of X, Y, and Z. And I think I had said, but nothing has limited you from seeking discovery from other sources via subpoenas yet. And I think you conceded that. You were, as I recall, you were upfront about that. So now here we are, and now we're having another discussion over whether to propound discovery is limited just to between the parties, or whether it covers to discovery to witnesses and non-parties. So that's where we are. And I was trying to think back on what we all said for all sides during that hearing, but that's where it sort of comes down in my mind. And that you specifically had mentioned something about a longer time. And I guess the question is, if you had gotten that order and you had any doubt about whether it applied to issuing subpoenas or not, should you have brought forward something to clarify that before now?
Your Honor, I had no doubt that it didn't apply to subpoenas. That's the position we've taken in our briefing. It does say propound discovery, but then it says defendants have 30 days to respond. It says defendant, not defendants and third parties. But it says, so I didn't seek to clarify it because I thought it was abundantly clear. At the hearing, we did talk about subpoenas. I said, so originally I had said, Your Honor, you're exactly right. I had said, I think in our whatever scheduling order we put down, when we put down all the rest of the deadlines on experts and trial date and all that, my position was our one issue of conflict between us and defendants was I wanted to build in some additional time to finish up written discovery. And my position at the hearing was our experts need this data, so we need some more time to finish up written discovery. That's going to be meet and confer. And then I think that's when the subpoenas came up, which was we may need to issue subpoenas if we can't get this data from defendants. But in any case, that's what I was asking for in terms of a scheduling order. I set that aside because the panel explicitly said during the hearing, we're not going to put in place a scheduling order right now. We're going to deal with the motion for interlocutory appeal and to revise first. And so when I got this order specifically applies to the oral motion by its terms. Plaintiff made an oral motion to propound additional discovery. I read that to be, this isn't the scheduling order. We're going to get to the scheduling order later. This applies to the whole discussion. Judge Tidwell had a lot of questions for me about what additional data do you need? And does this fall in under your original discovery requests, or are you saying you need more discovery from the defendants? And I took the position, it's sort of a little of both. Some of this applies under the original discovery requests. Certainly the race and ethnicity data does. Some of it, I think, falls under it, but maybe out of an abundance of caution, we should do some additional targeted supplemental discovery requests to the defendants. So there wasn't any lack of clarity in my mind in what this order was. It was the court has decided you probably should have sent whatever discovery you wanted to send to the defendants before. You sent some, maybe you should have covered your bases a little bit more. So we're going to give you a little bit of room to do some additional targeted supplemental discovery to the defendants on the topics that you, Mr. Habenreich, mentioned during the hearing. This is what you said you needed. So here's your order. You got 30 days to send supplemental discovery to the defendants. But in my mind, our discussion of around subpoenas at the hearing was, I'm not sure if I need to get these via subpoena because I can't tell what the defendants are going to give us and what they're not going to give us. And failing that, how could I have known when I was supposed to send subpoenas or not? I mean, I'm not in the habit of sort of sending multiple additional subpoenas for documents that I'm already seeking from the parties. If I think I'm going to get it from the party, I don't need to send a subpoena. It was only once it became clear that I wasn't going to get it from the defendants that sort of phase 2 popped in, which was, okay, I need to go ahead and send. And it's not like we sent, 20. We just sent 2 covering, a relatively narrow category of things. But again, these are subpoenas to third parties. Defendants don't have to respond to them. It's no prejudice to them. It's just great. We didn't get it from defendants. We need to get it elsewhere. So to answer your direct question, Judge Cook, in my mind, we were going to get a scheduling order. There probably would be deadlines for this kind of thing in there. And I agree, there should be deadlines for this so that we don't have any any disputes going forward. But to my mind, this was just on a narrow sort of oral motion around supplemental discovery to the defendant. So that's why I didn't. And we just sent our discovery requests.
Your Honor, just briefly, again, just looking at the case record in this case, plaintiff issued the subpoena to the Department of Correction on November 9th. She served it on the Department of Correction on November 21st. And then defendants, as she said, didn't respond to her discovery request until December 8th. So she's already anticipating that she needs to serve third-party discovery on other entities besides defendants in this case.
So small detail here, it looks like the subpoenas were actually issued within the deadline, but served outside the deadline when I was charting out. So, I mean, if it was issued, but it hadn't been served, but if they went and issued these within the timeline, then isn't this sort of an academic argument as to when they were served versus when they were issued?
No, Your Honor, because it would be the same thing if, you know, plaintiff drafted discovery requests within the deadline, but then served them after defendants as well.
Fair enough.
Well, but if they're filed by the court, if they're filed with the court within that time frame, I've never known. And again, this is just what we do in Division I of Circuit, Shelby County. But if discovery is issued and it's filed within the time frame, and there's some delay in serving it, then we have to look at the reasonableness of what the delay was. And normally a subpoena is served by a third party. It's not like an interrogatory where you file it and then you mail it or you email it. Normally there's a third party that's serving that subpoena. It could be a private process server, it could be a sheriff, perhaps it could be done by certified mail, but I think that there's a distinction between subpoenas being issued within the time frame and other types of written discovery being issued and served.
And all I'll say on the timing, Judge Cook, is that, again, I in no way imagined that this October 11th order applied to subpoenas. So I wasn't trying to serve them within the 30-day time frame. I was trying to get our supplemental discovery out and then find out from defendants, which is why I sort of went through that. You know, we had a meet and confer on the November 3rd, and then we sent a deficiency letter on the 21st, and then we had another meet and confer on December 7th. All of that interstitial stuff was me trying to figure out, are we going to get this from defendants, or do I need to send subpoenas? I wasn't sort of operating in the frame of mind like, boy, if I'm going to send any subpoenas, I need to send them within 30 days because the order didn't read that way to my mind. And that was not my recollection of the hearing. I thought, okay, if I can't get it from defendants, then I've got some time to, you know, I just need to get it via subpoena. And so that's what we did. But it's not as if we delayed. I guess that was the point I was trying to make, which was as soon as it became clear from our discussions with defendants, and particularly on December 8th, when we got their written responses, as soon as it was clear we weren't going to get this from defendants, some of it became clear a little earlier, which is why we sent the TDOC subpoena earlier. Some of it became clear a little later, which is why the OLS one went out a little bit later. But as soon as it was clear that we weren't going to get it from defendants themselves, we didn't wait 3 months to send them. We issued the subpoenas.
I just have one. Okay, Judge Cook, I'm sorry. You go ahead, Judge Cook.
No. I just said fair enough, but yeah, that's all.
Okay. I just have one little sidebar. Speaking on the scheduling order, when we were last at our last status conference, we said that we were going to take up the scheduling order today. And both parties have submitted proposed scheduling orders, and I have copies of them in front of me. But not to get ahead of us, but in terms of the proposal, we have one, and I'm not sure which party has proposed this. I believe it's the defendant. The first date on that proposed scheduling order is May 8th, 2024 for plaintiff's expert disclosures. I believe on the plaintiff's proposal, the first date on this scheduling order is July 31st, 2024, and that is for the conclusion of fact discovery. So whichever date we select, or if the court decides to impose a different date, this is March, so we have the remainder of March, we have all of April, and we would have up until May 8th. So again, I'm asking, what would be the prejudice to allow the subpoena, to allow the Department of Commerce, the Department of Corrections and the Office of Legal Services to comply with the subpoena? What would be the prejudice if the first date on defendant's scheduling order is May 8th for the cutoff of expert disclosures? So assuming that the subpoena can be complied with within 30 days from today, that would put us into the first week of April. That would give the parties 30 days to file their disclosures. So, plaintiff's experts. So if the plaintiff is able to receive this data, the experts are able to review it, they would have a whole 30 days to file their disclosures. That's not depositions or anything. And that's just according to the state's or to the defendant's proposal. Now, under plaintiff's proposal, they are asking for an August 7th of 2024 deadline to disclose their reports. But they don't have a date in here to make the disclosures in terms of who their experts would be. I don't see.
That's what we meant by that August date, Your Honor.
Okay.
And
so
we can disclose their names earlier, but. Okay,
so not the report, because there's a difference between the disclosure and then the report. But you're just referring to the disclosure, the Rule 26 disclosure.
Correct, Your Honor. Not to get too into the weeds, but we had objected originally to their discovery requests as untimely, as Mr. Wilson points out. And so usually you have to ask an interrogatory to get the expert information. In any case, we have no objection to disclosing who our experts are whenever we need to. That's not a secret. I think that the issue that we have, and skipping ahead a little bit, is since we're still waiting on this data, we have not been able to continue our meet and confer with TDOC or Office of Legal Services because of these pending motions. We are and frankly, we've been continuing to sort of have our meet and confers with defendants as well, but we don't have the voting data yet. We're waiting on that still. We anticipate that hopefully we don't need to be back in front of the panel on a motion to compel with respect to anybody, but we might, because we don't know what we're going to get yet. And so we're trying to make sure that we build in some time, given that we have a trial date in March. We want to make sure that we build in some time to get through whatever final issues with written discovery we're going to have, if any. Flush all that out, be done with it. And then we can do depositions, party depositions, because our experts are likely going to need some of the testimony from those party depositions to do their expert reports, particularly on, the state's purported interest in these statutes and those kinds of things. So we're trying to sequence it out to say, let's finish up written discovery. Let's make sure we leave enough time to where we don't have to come back and try to amend the order again. Give enough time for us to get whatever we're going to get. We can evaluate it, give it to our experts. If they say this isn't what we need or we need to follow up, we have time built in for that. And then we do our party depositions. We do our expert reports and expert depositions. And then into the sort of late fall, we get into dispositive motion briefing. But again, we're trying not to, given how hard it's been to get to this point, and given the fact that we still have potential disputes with TDOC and with OLS, we point out in our briefing, Mr. Peterson will talk about, we don't have a privilege log from them. We don't know what searches they've done. Defendants, we don't know what searches they've done, or the custodians. This has been ongoing discussions between us and the defendants around search terms and custodians and how far back did you look? We don't know any of that. And so we have no idea if we have a complete set of documents, and those things need to get worked out. We're trying to work them out amicably so that we don't, have to get in front of your honors on this, but we do need to leave some time to resolve that kind of stuff. So I think that's where you find the difference between our two, is to just make sure that we can, both sides get whatever they need. We can be done with written discovery, but I don't think it's reasonable to say, we're in March, to say we're going to be somehow done with all of our written discovery in the next, 4 weeks or 6 weeks. And that's even if we got an order today telling OLS and TDOC start producing, we don't know when we're going to get documents. We don't know what they're going to produce. We don't know if we're going to have objections, and we've got to restart that process. And so I think we're trying to be realistic and make sure that we leave enough time to resolve all of this stuff before we get into everything else.
Okay, Mr. Wilson, your office represents LOS, is that correct?
Yes, the Office of Legal Services. Yes, Your Honor.
Okay, and the motion that's before us now has been filed by the defendants, but if the motion is denied to Quash, should we anticipate the Department of Corrections, will you be representing them as well and filing a separate motion on their behalf, or do you anticipate that they would comply with the subpoena?
Your Honor, I do not represent the Department of Correction. But to go back a little bit to your earlier point and question of what the prejudice is, it's that plaintiff is taking the position that she can serve third-party discovery regardless of any discovery cutoffs or any deadlines at her whims. That she has no authority to support that. There's nothing in her brief about that, and she doesn't dispute anything that the defendants have raised in their briefs about just third-party discovery being discovery devices that are subject to discovery deadlines. Your Honor, so again, she hasn't explained why there was no reason why she couldn't have served third-party discovery earlier as well.
All right, well, thank you, Mr. Wilson. Any other questions, judges?
No.
All right, any final comments? Mr. Wilson, we'll let you go first since it's your motion. Any final comments?
Your Honor, we would just request that the court grant the defendant's motions to quash and for protective order. Thank you.
All right. Okay, well, thank you. Okay, so now let's move to the next motion. And I think Mr. Peterson is going to argue this for the plaintiff. Mr. Wilson, whenever you're ready with the next motion, you may proceed.
Thank you, Your Honor. Sorry, it's just switching gears a little bit here. Again, Robert Wilson on behalf of the Tennessee Attorney General's Office and here on behalf of the non-party Office of Legal Services for the General Assembly of Tennessee. The Office of Legal Services is entitled to the absolute protections that Article 2, Section 13 of the Tennessee Constitution provides regarding absolute immunities and privileges from suit and evidentiary protections that are available to members of the General Assembly for all of their legitimate legislative activities. That involves, in taking the clause as a whole, to paraphrase at least the first part, Article 2, Section 13 provides that senators and representatives shall, in all cases except for treason, felony, or breach of the peace, be privileged from arrest during the session of the General Assembly. What we're focusing on here is the second portion of that provision, which provides that for any speech or debate in either house, those senators and representatives shall not be questioned in any other place. And in looking at that provision, the Tennessee Court of Appeals in Mayu versus Wilder concluded that the speech or debate provision in the Tennessee Constitution is nearly identical to its federal counterpart, and that also that the decisions interpreting the federal counterpart, which is Article 1, Section 6, or the speech or debate clause, to differentiate between the two, that cases interpreting that clause would be helpful in interpreting the Tennessee Constitution's identical provision. And when you look at the federal case law and interpreting the clause, they find two purposes that the provision serves. One is that it serves as a separation of powers of co-equal branches of government. So it helps to ensure and enshrine that the legislative, executive, and judiciary are separate divisions and have separate powers alone. And also another purpose is that it provides for legislative independence. So taking those together, the purpose of the speech or debate clause allows legislators to focus on their legislative duties and prevents other branches of government from requiring those legislators to divert their time, energy, and attention from their legislative duties to participate in litigation. What you also find in the case law interpreting the speech or debate clause is that the term speech or debate are interpreted broadly to prevent any inquiry into actions that the Supreme Court has termed the sphere of legitimate legislative activity. So basically what that does is prohibits inquiry into those things generally done in the performance of legislative duties or that are integral to the legislative process, and also into the motivation for those acts. And that's under the Supreme Court's decision, United States versus Brewster. What other courts have also determined is that the speech or debate clause provides an absolute bar to interference with legislative activities that are determined to fall within the legislative sphere. And all of the evidence in this case that's before the court shows that the Office of Legal Services provides only services that are within that legitimate legislative sphere. The statutory duties of the office are included at Tennessee Code Annotated 3-12-101. Those statutory duties involve the preparation, formulation, and proposal of legislation in aid of General Assembly members, and the declarations that we've submitted, that the Office of Legal Services has submitted with its motion from the directors of the Office of Legal Services from both the for the House and the Senate of the Tennessee General Assembly. Those declarations provide that either the directors or other Office of Legal Services staff provide legal services regarding the formulation, proposal, or enactment of legislation to members of the General Assembly, and that they're only authorized to provide legal services to aid General Assembly members in the discharge of their official legislative duties. And the declarations also show that they're not authorized to provide legal services that would fall outside of that sphere of legitimate legislative activity, such as providing legal services to members on personal legal issues or their aides, writing press releases or talking points, or any other administrative or secretarial functions, or to respond to constituents either. So with all the evidence before the court falling within the legitimate legislative sphere, the legislative immunities and protections that fall from the speech or debate clause or speech or debate provision of the Tennessee Constitution should attach the Office of Legal Services and prevent the plaintiff subpoena ducis tecum requesting documents from the Office of Legal Services. We'll note that plaintiff in her response relies largely on a rule derived from federal criminal proceedings in the Third Circuit, and that has also been adopted in federal criminal proceedings in the Ninth Circuit, saying that the protections that the speech or debate provision or clause provides only provides an evidentiary protection rather than a non-use. But there's nothing within the plain text of the Tennessee Constitution that qualifies that any protections are just for non-use rather than non-disclosure. There's no qualifiers on the Tennessee Constitution's text that senators and representatives shall not be questioned in any other place. And as the Supreme Court of Virginia found in interpreting the Virginia Constitution's similar speech or debate clause, it found that the term question should be construed broadly to mean subject to examination by any other body. So taking it together, the clause provides that it shall not be subject to examination by any other body regarding speech or debate, which we've already discussed includes the full sphere of legitimate legislative activity. And not only does the Third Circuit's rule it shouldn't be applied here because it's not supported by the text of the Tennessee Constitution, but it's also not consistent with any of the purposes that we've discussed behind the speech or debate provision, which again are to ensure the separation of powers and also legislative independence from interference with legislative duties. And there are several cases that have rejected the Third Circuit rule outright in interpreting the speech or debate provision or clause. One is the DC Circuit in the Brown and Williamson case, that considered the application of the Third Circuit rules and found that it would interfere with those purposes, as well as the Southern District in New York's SEC versus Committee on Ways and Means case that was decided in 2015. And then state courts also have rejected as well, including the Arizona Court of Appeals and the Arizona Independent Redistricting Commission. And we cited through all those cases throughout our briefs here. And not only that, but recent cases from the Federal Court of Appeals have, while not explicitly denied the Third Circuit's rule outright, they've all concluded that the protections that either the speech or debate clause provides or its related common law rule it doesn't apply or bars requests for compulsory evidentiary process, including the compulsion of evidentiary, for the compulsion of the production of documents through a subpoena, excuse me, Your Honor. And that includes the 8th Circuit and the NRA North Dakota Legislative Assembly, La Union del Pueblo in the 5th Circuit, NRA Hubbard in the 11th Circuit, the EEOC versus Washington Suburban Sanitary Commission in the 4th Circuit, and then other state courts have adopted that rule as well, including the Virginia Supreme Court's Edwards versus Visselin decision, and then also recently within the last 2 weeks, the Iowa Supreme Court in the Smith versus Iowa District Court decision, and we've also cited to those in our briefs as well. And I don't take plaintiff's response to be any dispute that the protections that the Tennessee Constitution's speech or debate provision applies to legislators, not only to legislators themselves, but also legislator staff and aides or other alter egos. And I think the case law is clear on that, at least since the Supreme Court's decision to gravel, that it does apply to people that are involved within the legitimate legislative sphere. And because the protections of the speech or debate, Tennessee Constitution speech or debate attaches here, and considering plaintiff's claims that she's seeking to discover the intent of the legislatures in passing or in formulating, proposing, and enacting legislation, there's no need to provide a privilege lock here. And I point this court to the 11th Circuit's NRA Hubbard decision, which is instructive. So what that court decided was that claims that strike at the heart of the purpose of the protection, when a party requests through a subpoena information that is only inside the sphere of legitimate legislative activity, making a privilege log is unnecessary because all of those requests fall within there. And to the extent that plaintiff says that she requested documents that fall outside of that sphere of legitimate legislative activity, one, there's nothing in the record to show that the Office of Legal Services provides any such services outside of the legislative sphere. And two, those would be irrelevant to her determinations of trying to prove that her the challenge statutes were enacted with discriminatory intent. And same as here as the NRA Hubbard decision, requiring the Office of Legal Services to produce a privilege log in this case would defeat the entire purposes of the speech or debate clause, speech or debate provision in providing protections for the Office of Legal Services and the General Assembly to continue on with their legislative duties. If there are no questions, Your Honor, the Office of Legal Services asks that you grant their motion to quash and for a protective order.
Thank you, Mr. Wilson. Mr. Peterson, you may proceed.
Good morning, Your Honors.
Morning.
Good morning. Matthew Peterson on behalf of the plaintiff. As to this motion, plaintiff seeks the truth behind the development and passage of this state's felon disenfranchisement laws. The defendants in this case, as my colleague has mentioned earlier in this hearing, have suggested to this panel that some of plaintiff's claims should fail because plaintiff has not yet identified sufficient evidence of legislative intent behind the passage of the relevant disenfranchisement statute. And plaintiff originally requested documents related to the legislative history behind the state's felon disenfranchisement laws from the defendants. But other than producing a single document about the background of one of the statutes, defendants indicated that they did not possess the information that plaintiff was seeking. As a result, plaintiff served the subpoena at the center of this dispute on the General Assembly's Offices of Legal Services, OLS for short, a party whom plaintiff reasonably believes to possess information relevant to her claims. Subsequently, OLS filed this motion to quash. In considering this motion, the panel should keep in mind that the Tennessee Supreme Court has recognized that the purpose of all judicial inquiry is the ascertainment of the truth in pursuit of justice. And while evidentiary rules tend to illuminate the truth, privileges effectively shut out the light. As such, the Tennessee Supreme Court has cautioned that privileges are acceptable only when they serve a public good transcending the traditional predominant goal of ascertaining the truth. And here, OLS does not dispute that the documents requested are relevant to plaintiff's claims. OLS does not suggest that compliance with the subpoena would impose undue burden or expense. And OLS does not assert that the documents are protected by attorney-client privilege. Instead, OLS is asserting a privilege against disclosure that has never been upheld or supported by any Tennessee court, especially not when that assertion has taken the form of a blanket assertion of privilege. The panel should deny OLS's motion for two main reasons. First, the speech or debate clause of the Tennessee Constitution does not provide legislative actors with a non-disclosure privilege. And second, even if the panel is inclined to find that the speech or debate clause provides legislators with some degree of a non-disclosure privilege, the motion should be denied for multiple reasons, but most particularly because OLS has improperly made a blanket assertion of privilege. To the first point, that the speech or debate clause does not provide a non-disclosure privilege, and at most provides a non-use privilege. What's the difference between a non-disclosure privilege and a non-use privilege? Well, a non-disclosure privilege, like the attorney-client privilege, permits a party to withhold relevant documents from another party requesting them. On the other hand, a non-use privilege does not relieve a party of its obligation to produce documents responsive to a request, but the holder of a non-use privilege can exercise it in a legal proceeding to prevent those documents being used against them in that proceeding. Now, no Tennessee court has ever held that the speech or debate clause of the Tennessee Constitution relieves a legislative actor of their obligations to produce responsive, relevant documents. OLS does not dispute this. Instead, OLS relies exclusively on non-Tennessee state court decisions as support for the notion that the Tennessee speech or debate clause provides OLS a non-disclosure privilege. And it is true that in Mayhew, a Tennessee appeals court indicated that cases interpreting the U.S. speech or debate clause are helpful because of the similarities between the two provisions. But OLS mischaracterizes the state of the law when it comes to the interpretation of the U.S. speech or debate clause. OLS would have the panel think that the majority of courts to interpret the U.S. speech or debate clause have held it provides legislative actors with a privilege of non-disclosure, not just a privilege of non-use. But that's not the case. The vast majority of cases that OLS cites in its briefing as supportive of the notion that the speech or debate clause provides a privilege of non-disclosure were actually analyzing the federal common law's legislative protection afforded to state legislators in federal court. They were not analyzing the text or purpose of any speech or debate clause. 3 U.S. appeals courts have directly analyzed whether the provision of the U.S. Constitution, the speech or debate clause, provides legislative actors with a privilege of non-disclosure, and 2 of them, as OLS concedes, ruled, the Third Circuit and the Ninth Circuit, that the speech or debate clause only affords legislators a privilege of non-use, not one of non-disclosure. And notably, the Ninth Circuit in the Renzi case was the last circuit of these 3 circuits to analyze the issue. It had the benefit of the DC Circuit, of reviewing the DC Circuit cases upon which OLS relies, and the Third Circuit cases upon which plaintiff relies, and the Ninth Circuit joined the Third Circuit in concluding that the speech or debate clause only provides a non-use privilege. This is the interpretation that best comports with the language and purpose of the speech or debate clause. And that purpose is to prohibit evidence of a legislator's acts to be used in a proceeding against him or her based on a historical fear that legislators could be subject to prosecution by an unfriendly executive and conviction by a hostile judiciary. And this purpose is traced back to England, where the monarchy weaponized proceedings to manipulate members of parliament. But a non-disclosure privilege is not necessary to effectuate this purpose. By granting legislative actors a non-use privilege, no legislative act document can ever be used against them in a proceeding. OLS also cited 3 cases from other state courts as purported support for their position, But drilling into those cases, one would find that the Iowa case referenced by Mr. Wilson acknowledges that the Iowa Constitution does not even have a speech or debate clause. And the other two cases, the Arizona and Virginia cases, predominantly rely on the DC Circuit line of cases, which plaintiff submits to this panel got it wrong. Tennessee's Constitution evinces that Tennessee only has a limited that Tennessee doesn't really support the notion of confidentiality of legislative proceedings. Tennessee Constitution Article 2, Section 21 imposes an obligation on legislators to keep a journal of their proceedings and to publish it, subject to certain exceptions. And looking at this provision in conjunction with the Tennessee Speech or Debate Clause provision, really, the state of Tennessee has never suggested that it's trying to protect the confidences of the legislative proceeding. Ultimately, the Ninth Circuit and Third Circuit got it right in deeming that the speech or debate clause only creates a privilege of non-use to the extent it creates any evidentiary privilege at all as applied to documentary evidence. And this panel should accordingly dismiss OLS's motion on the grounds that the speech or debate clause does not provide a basis to not disclose relevant documents. As noted earlier, no Tennessee court has ever held a party could withhold relevant evidence on the basis of the Tennessee speech or debate clause, and this panel should not be the first. Turning to the second point, plaintiff raised a handful of grounds in her papers as to why OLS's motion still fails, even if the panel is prepared to hold that the Tennessee speech or debate clause provides a non-disclosure privilege to some degree. But in the limited time available today, plaintiff would like to focus the panel on how it should alternatively deny OLS's motion because OLS improperly makes a blanket assertion of legislative privilege. It's axiomatic across jurisdictions that blanket assertions of privilege are disfavored. OLS is effectively asking the panel to declare documents privileged without having any idea of what documents to which they would be applying the privilege. In other words, OLS is asking the panel to construe the Tennessee speech or debate clause and apply it to an unknown universe of documents. OLS makes a large deal about how the two bare bones affidavits from its directors establish that every responsive document in OLS's possession is the product of a legislative act. OLS is effectively telling the panel that OLS is making the privilege assessment and the panel should take its word for it. The panel should not do so. Even if the Tennessee Supreme Court had issued a definition of what constitutes a legislative act protected by the speech or debate clause, and OLS's directors had copied and pasted it into the affidavits, that still wouldn't be sufficient to meet their burden to establish that this unknown universe of relevant document should be withheld on the basis of privilege. That is because it's the province of the courts, not OLS's directors, not OLS's attorneys, to make the call on which documents are the product of legislative acts and which are not. Indeed, OLS cites as many cases involving either the production of a privilege log or in-camera review by a court than the couple of cases that OLS suggests supports the notion that OLS need not provide the panel with any description of the documents to which it asks the panel to apply a privilege. For instance, in the SEC case referenced by Mr. Wilson, that's the SDNY case in 2015, the court directed a party asserting the privilege to produce a privilege log and left open the possibility of in-camera review. Similarly, in the La Union del Pueblo case, the Fifth Circuit case cited in Mr. Wilson's briefing, there too, the party produced a privilege log. What's going on here in the briefings is that OLS is citing certain cases for the positions that support the arguments they're making, but are just completely ignoring the rest of the case that undercut the other arguments they're making. Ultimately, the issue here is that OLS is not giving the panel the ability to apply the guidance provided by the courts to determine whether documents are the product of legislative acts and subject to protection of the privilege to the extent this court is even prepared to recognize it as a non-disclosure privilege in the first place. And Mr. Wilson referenced the Brewster decision. Well, in that decision, the United States Supreme Court noted that it never indicated that everything related to the office of a legislator was shielded by the speech or debate clause. But that's effectively the position that OLS is taking here today. Mr. Wilson also mentioned the guidance provided by the courts that the protection extends to anything that relates to the due functioning of the legislative process or what's integral to the legislative process. But OLS's response in the affidavits provide no details sufficient for this court to apply the guidance from the United States Supreme Court to the documents, again, to this unknown universe of documents. Indeed, there are potential non-legislative act documents that cannot be ruled out on the basis of the affidavits and the assertion of privilege here. For instance, the United States Supreme Court held in Helstocki that promises to perform future legislative acts do not fall within the protections of the speech or debate clause provision. So for instance, if OLS sent an email to a senator or perhaps to an outside interest group promising to draft a bill on felon disenfranchisement, that would not fall within the ambit of the privilege. But we can't rule out whether or not documents like that and promises like that exist based upon the limited information that OLS has provided the court. In addition, in the Brown and Williamson case, which OLS heavily relies upon, the DC Circuit noted that the dissemination of investigatory information to the public does not qualify as a legislative act within the ambit of the protection. So if OLS had conducted an investigation on the effects of disenfranchisement on recidivism or public safety, which are some of the documents that plaintiff has requested, and forwarded that to an outside party, then plaintiff would submit that that too is not subject to the protection of the speech or debate clause to the extent this court recognizes it as a non-disclosure privilege. But again, the information that OLS has provided this court and its directors have put in their affidavit does not rule out the possibility that documents like that may exist. As such, the panel should not accept OLS's invitation to blindly make a privilege determination over documents that it's not even clear OLS has identified for themselves in the first instance. And for all the aforementioned reasons, this panel should decline to become the first Tennessee court to hold that the speech or debate provision of the Tennessee Constitution provides a basis to withhold relevant documents. Instead, the panel should hold that the provision at most provides legislative actors a non-use privilege. However, even if the panel is not convinced, it should still deny OLS's motion because their blanket assertion of privilege does not provide the panel with any meaningful basis to assess whether it would be proper to apply this privilege to an unknown universe of responsive documents. Thank you very much.
All right, thank you, Mr. Peterson. Mr. Wilson, any reply?
Yes, Your Honor. Our friend cited to the Third Circuit's opinion finding that there's no, I guess, secrecy in legislative proceedings, but that's foreclosed by our own Tennessee Court of Appeals opinion in Mayu, which is referenced, which found there's no constitutional or common law right to attend legislative proceedings, and that's not subject to judicial review as to when the legislature decides to close its proceedings. And going back to my friend's argument about the privilege log, I don't hear any distinguishing features between what the information that she's seeking from the Office of Legal Services, which goes to the intent of the passage of her challenge statutes, and any distinguishable claims from what N. Ray Hubbard in the 11th Circuit decided were striking at the actual heart of the privilege in the first place, which protects against judicial inquiry from not only the actions of legislators or their aides, but also their motivations in enacting legislation. And also, the only evidence that's before this court are the declarations of the directors of the Office of Legal Services. Plaintiff hasn't identified any other evidence to show that the Office of Legal Services is functioning outside of the legislative sphere, and there's nothing to point to in the statutory duties that would also encompass that. Plaintiffs also made a reference that communications to third parties would not be covered, but the Fifth Circuit's decision in La Union del Pueblo found that if it's involving legislation, communications with third parties is also protected within the immunity. And that also gets into another point where plaintiff says that the cases relied on that distinguished or did not adopt the Third Circuit's rule were applying the common law rather than the speech or debate clause. But there's countless cases that hold that the rationales between the speech or debate clause or speech or debate provision of the Tennessee Constitution and the common law that both have their taproots in the parliamentary procedures in England are both applicable. The only difference is is that the constitutional provision provides absolute protections both from suit and from evidentiary process, while the federal common law decisions show that that can be a qualified privilege that could be overcome in certain unique circumstances. And I'll point to, not only First Circuit's Alvetti decision, but also what's cited by plaintiff in the Favors versus Cuomo from the Southern District in New York case that also says the courts have interpreted the speech or debate clause to provide members of Congress with absolute immunity from suit, as well as from compelled discovery or testimony. So even their own cases support the notion that that these provide absolute protections.
Sorry, could you repeat that? Where are you reading that from? Is that what part of the statute?
That's the cited in plaintiff's brief Favors versus Cuomo decision that she cites throughout, where it says that courts have interpreted in the federal clause, the federal speech or debate clause to provide members of Congress with absolute immunity from suit, as well as from compelled discovery or testimony. And that's also consistent with the First Circuit's decision in Alvetti as well, in relying on the case law for the speech or debate clause and also the federal common law as well. Plaintiff also notes that that we referenced the Iowa decision the Iowa's constitution does not include a speech or debate clause provision. That's true. But what the Iowa Supreme Court did was synthesize the case law and go through the history of why absolute evidentiary protections would apply to state constitutions or the federal constitution that include the speech or debate clause, and why Iowa's privilege, which is only based on separation of powers because it doesn't have that speech or debate provision, would only provide a qualified immunity or protection that could be overcome in certain circumstances. Of course, the Iowa Supreme Court found that even though it was qualified privilege, it wasn't overcome there. And again, we hear from plaintiff that she needs all of these documents, but there's no indication that she's been unable to seek legislative history from other publicly available sources that would help to discover the intent. What she's trying to do is exactly what the clause protects against, which is to dive into the actions and motivations of the specific legislators themselves. And that's barred by any interpretation of the federal speech or debate clause, which may use noted or be particularly helpful in interpreting Tennessee's own provision. And as a final point, plaintiff makes a lot of argument about how no Tennessee case has decided this, but the Tennessee Supreme Court in Phillips versus Montgomery said that just because that the issue hasn't passed either an appellate court doesn't mean that the Tennessee Constitution should be interpreted as providing less protections, but rather you look to, say, other sources or counterparts. And when there's no textual or historical basis from treating the Tennessee Constitution different than its federal counterpart, then this should be interpreted in a similar manner. And for those reasons, we think that the federal cases interpreting the speech or debate clause and also the speech or debate protections that are available at common law that also help explain why legislators are protected both from suit and from compulsory evidentiary process are applicable to this court's determination. If there are no further questions, we again ask that the court grant the Office of Legal Services motion to quash and for protective order.
All right, thank you, Mr. Wilson. Okay. Any questions, judges, or comments? No? Okay. All right, well, pretty interesting arguments on both sides. I just need a little clarification, and this either Mr. Wilson or Mr. Peterson. Is there any case or statute that specifically states in Tennessee that legislative acts, or when the legislature acts, that their notes, records, documents, research, recordings are not discoverable in a legal proceeding where they are not a party. I understand the no use privilege that and the immunity as it relates to our legislators, that they are immune from suit when they're acting within the scope of their legislative acts, that they cannot be compelled to testify or to present evidence or just to be compelled to an evidentiary process, such as a deposition. But this lawsuit is not involving the legislator. There's no legislator or legislative body that's been named as a defendant. So help me understand, Mr. Wilson, are you arguing that, because we want our legislative body to be transparent, the public and the citizens have a right to understand how our legislative bodies pass laws and certain acts. So I'm having a hard time understanding how the speech and debate clause would protect a party, such as in this case, from discovering any documents that would be available, recordings, notes, et cetera, of how our legislators came about passing certain laws, what was contemplated, what was discussed, because we know what the allegations are in this case as it relates to certain acts and allegations that Ms. Moses has made in this lawsuit. So does the debate and the speech and debate clause shield the legislative body and the office of OLS from disclosing documents and recordings that could be relevant to determining whether or not there was any discriminatory intent with the passage of certain statutes or acts that are relevant to this particular case? If Ms. Moses and the plaintiff is not attempting to bring a suit against these legislators or the body, but she's simply trying to determine whether that there was any improper purpose, any discriminatory purpose, why should we construe the speech and debate clause as preventing a blanket shield where that evidence, if it's available, because it would be relevant to the lawsuit, and under Rule 26.02 of the Tennessee Rules of Civil Procedure, parties may obtain discovery regarding any matter which is relevant to the subject matter involved in the pending action if the information is sought or appears, if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. So in Tennessee, we have our sunshine law, and I understand that there are certain laws that apply to our legislative process. But I'm trying to understand, where is the legal support, either in a case or a statute, that specifically states that these types of records are not discoverable in a proceeding where the evidence may be relevant or may lead to evidence that is reasonably calculated to lead to the discovery of admissible evidence? Okay, hopefully, I know there was a lot of questions in there, but if you could maybe start with the last one first, that would be great.
Your Honor, I believe what you're trying to ask is if the Office of Legal Services is attempting to block the publicly available records of legislative proceedings. So such that would be posted, say, on the Tennessee General Assembly's website. That's not what the Office of Legal Services is attempting to block, or saying that the Tennessee Constitution provision applies to. Rather, what it does apply to is the actions and motivations of the legislature in the proposal, enactment, and formulation that are not publicly available.
Okay, well, let me stop you there. So again, I'm looking at the discovery, I'm looking at the subpoena, and on page 5, for example, the first request is all memorandum, presentations, notes, research, communications, audio recordings, video recordings, and other documents related to the ineligibility of persons to register and or vote by virtue of being convicted of felon. So put it in that context. Let's deal specifically with what is being requested as opposed to just an overall blanket approach to what the mental impressions of the legislators may have been. Because we know with any privilege, say for example, when you're dealing with the attorney-client privilege, yes, an attorney's mental impressions about a case would be protected. But an attorney can't take the position that everything in my file is necessarily protected by the attorney-client privilege. It may very well not be. And that's the purpose of a privilege log. And this court reviews privilege logs all the time and will make a determination page by page, document by document, recording by recording, whether or not that document or that recording falls within the scope of the privilege. So I understand that there may be certain aspects of what a legislator does that may be protected, but let's deal with it within the context of what's being requested.
Certainly are. We didn't interpret that as asking for publicly available information. To the extent it is, there's no indication on this record that Ms. Moses isn't able to go to the State Library and Archives and request these publicly available recordings from the General Assembly. So, but in not only should we look at her subpoena requesting documents relating to the formulation, proposal, and enactment of her challenge statutes, we also need to look at the what she's alleging as well, and that it was passed with discriminatory intent. What she's trying to get at least our interpretation of the subpoena, is that she's trying to get into the mental impressions or the actions in the legislative process, which are protected by the clause specifically. Again, we'll relate to N. Ray Hubbard. Of course, we note that the clause or the speech or debate provision of the Tennessee Constitution doesn't apply to all activities. It wouldn't apply, for example, to publicly available sources, which again, there's no bar from plaintiff getting those sources from the State Library and Archives, which again are publicly available to even the party, all parties together in this case. But what she's trying to get is what goes beyond what's publicly available and attempting to grab documents relating to the proposal, formulation, and enactment of legislation that aren't available in the public record to try and show discriminatory intent. Again, but requiring the Office of Legal Services to go search through those documents and find and produce them are exactly what the Tennessee Constitution protects against, which is to prevent judicial inquiry into the legislative process and into the actions and motivations that fall within the legitimate legislative sphere. And again, the Tennessee Constitution, through the speech or debate provision, both enshrines both the purpose of separation of powers to prevent both co-equal branches from coming into the legislative function, and also for legislative independence as well, to allow those actors and their staff and their aides to do their legislative duties.
All right, thank you, Mr. Wilson. Mr. Peterson, you want to address that question?
Yes, Your Honor. To the extent that Mr. Wilson is suggesting that some of the documents might not be relevant to plaintiff's claims, plaintiff would be amenable to the production of the documents under a protective order so that eventually the only documents that come to light are those relevant to plaintiff's claims. Moreover, Mr. Wilson likes to focus in how the requests are trying to go to the intent of the legislature, but the privilege that imbues from the speech or debate clause, to the extent it's even recognized as a privilege in the first instance, the case law is pretty clear that it turns on the nature of the legislative act, not whether it involves a motive of a legislator or not. For instance, if a legislator went out to a meal with a third party and said, I'm interested in passing this legislation for X, Y, and Z, that's not a legislative act. It's not part of the due functioning of the legislative process. And therefore, the court should be looking at the nature of the act that produces like the document, as opposed to the fact that it relates to motive of the legislator. That's not what the case law supports. So thank you, Your Honor.
Okay. All right, judges, any other questions?
I have a question.
Yes, Judge.
I have one. Can you hear me? I'm having a connection. Sorry.
Yes, yes, we can hear you. Yeah. Okay, we just lost Judge. All right, she's back.
Sorry, I'm back. Can you hear me or see me? My connection is going in and out. I'm sorry.
Yes, we can.
If you can hear me, my question was, okay, sorry. My question would be,
I believe Judge Cook dropped out again.
Okay, I think she's trying to come back on.
parties be protected.
Okay, Judge Cook, we lost you for about a minute there. Could you please restate your question?
Sure. My question is, what is the state's response to this concept of the communications with third parties would not be privileged?
Your Honor, as we pointed out in our brief, the Fifth Circuit's recent decision, La Union del Pueblo, says that the protections of the speech or debate clause or the federal common law applies to communications with third parties that involve the formulation, proposal, and enactment of legislation. I think I'm not sure if we lost Judge Cook, but to the extent that plaintiff is seeking documents from the Office of Legal Services that are outside of the legislative sphere, they're either irrelevant, and there's no evidence that the Office of Legal Services even functions outside of the legislative sphere. Again, the declarations and the statutory duties all show that the Office of Legal Services provides General Assembly members with legal services revolving the formulation and proposal and enactment of legislation, and functions to aid General Assembly members in the discharge of their official legislative duties. So plaintiff hasn't pointed to any evidence that the Office of Legal Services is operating outside of that sphere.
All right, so separate and apart from what the attorneys within that office may have communicated with their client or any work product, if there are any other documents that may be in that office that would be admissible, would be discoverable under Rule 26.02, what is the case of the statute that you contend clearly states that these types of documents or recordings, as it relates to these specific statutes which have been cited in the subpoena, are not discoverable? I really want to drill down on that, because I understand with all of these cases, the federal cases, and little bits and parts of these cases, but is there any specific case that states that they are not subject to discovery in a proceeding such as this?
And Your Honor, are we just for my own clarification? Are we talking about, say, like the publicly available videos of the Tennessee?
No. I'm not talking about public records and legislative history and things that the plaintiffs can get off of the public realm. No. But to the extent that there are documents, notes, recordings that are not part of the legislative history that would be within either the legislator's office or the office of OLS. We're talking about those documents to the extent that there are any.
Your Honor, we would rely on, again, the interpretations of the speech or debate provision or the related speech or debate clause in the federal counterpart to show that the parties can't subpoena the legislature for documents revolving their motivations or actions and that are integral to the legislative process. And that would include third-party discussions as well that involve the proposal and formulation and enactment of legislation as well.
Okay, Mr. Peterson, do you agree or disagree that this, and I think I know the answer, but I just want to make sure that the speech and debate clause prohibits discovery through a subpoena such as what's been issued to OLS or the legislature to determine whether or not they had any discriminatory intent in passing any specific statute that may be relevant to this particular case. Is that not permitted according to our law or constitution?
Your Honor, plaintiff submits that the speech or debate clause of the Tennessee Constitution does not protect the disclosure of documents going to the intent of the Tennessee legislature behind the passage of the law is relevant here. And in response to some of the points that Mr. Wilson made about whether certain documents would be relevant or not, it's hard for this panel to even make that determination because this panel hasn't even been given a description of the documents in the first instance. If we look at the cases relied upon by OLS relating to communications with third parties, such as the DC Circuit case, which they heavily rely upon, even that case suggests that certain communications with third parties, such as sharing investigatory information with third parties, do not fall within the ambit of the speech or debate clause protection. But again, the affidavits and the motion do not give this court sufficient information to make a universal blanket ruling on privilege to an unknown universe of documents, and the panel shouldn't have to be entertaining that type of an assertion in the first instance. And the only other point I'd make, Your Honor, is that Mr. Wilson has suggested that plaintiff hasn't come forward with evidence about the functions and the documents within OLS, but as the moving party in the motion to quash, it's OLS's burden to convince the court to apply this privilege to every document that's responsive that it claims the privilege should be applied to. Thank you.
All right, so for example, on page 5 of your subpoena number 2, just for an example, all memoranda presentations, notes, research, communications, audio recordings and video recordings and other documents related to TCA 4020-112, TCA 4029-105 C2B, or Tennessee Code Annotated 4029-204. Can you share with the court what you anticipate may be available? What specifically are you seeking other than documents that would be available within the public realm, such as the legislative history?
Your Honor, plaintiff would be curious to know whether the assembly conducted any research or analysis on the effects that disenfranchisement might have on things such as recidivism or public safety. That specifically goes to request number 15 on page 6. Those are some justifications that plaintiff anticipates the state might offer as the purported justification for the disenfranchisement of convicted felons. If there was no research or investigation conducted, that might be probative to show that the motive that is being provided in the public records and in the public domain might not be what actually motivated the passage of the laws.
Okay. Any other examples of the types of documents, recordings?
Let me ask, can I go back? If their response is no such documents, isn't that the answer? In other words,
I'm sorry, could you repeat that, Judge?
If the response from the state, if this motion will be denied, is there's no such information, doesn't that answer your question?
Well, Your Honor, OLS hasn't suggested to us in their papers that no such document exists. And when plaintiff indicated in their reply brief that there was no indication that OLS has conducted any search of their documents at all to determine what documents might actually be responsive to our requests, OLS didn't reply and indicate that such a search had taken place. But moreover, to Judge Corbin Johnson's point about what other documents we might be interested in, perhaps there were communications with third-party interest groups who were interested in this legislation, and the fact that those discussions were being had and not an integral part of the legislative process might give us an idea who else might have relevant information, and plaintiff would be able to potentially engage in discovery with those parties who wouldn't be able to assert the protection of the speech or debate clause of the Tennessee Constitution.
Okay. Any other examples you'd like to offer? Those two examples are helpful.
Your Honor, ultimately, it's just hard to give a comprehensive sampling of what examples might apply to carve out the speech and debate clause protection to the extent that the court's prepared to recognize one, just because OLS hasn't provided plaintiff with any sense of the document. So it's truly hard to look at all the case law and know what exception and what ruling that has been found to say this document clearly doesn't apply would be relevant to our circumstances here, because quite frankly, plaintiff is kind of approaching the issue a little blindly based upon the lack of information provided by OLS.
Okay. All right, well, that's fair. Mr. Wilson, any final comments? Or let me ask the judges first if they have any more questions before you make final statements.
No.
Okay. Judge Cook, are you back with us? Okay. I think she's having some trouble with her camera. Judge Cook, are you there? Okay, let's give her a moment.
Your Honor, while we're waiting, do you mind if I step away to take care of something just for a moment?
Okay, that's fine.
Thank you.
I'll tell you what, why don't we take about a 5-minute recess, and then we'll come back in about 5 minutes, because we've been going about an hour and almost 2 hours. So let's take about a 5-minute recess.
Thank you, Your Honor.
All righty, thank you.
I'm going to open up the break rooms.
Okay, looks like everyone's back. We'll just wait on Mr. Williamson to take us live.
Yes, ma'am, you're live.
Sorry, y'all, my internet has gone down. So what I've done is go to my cell phone, which has a different internet carrier, but my internet here through the county is gone. I don't know why. Sorry about that.
Oh, no problem. We just took a recess.
Okay.
Okie dokie. All right, Mr. Williamson, are we back on streaming?
Yes, ma'am. Yes, ma'am.
Okay. Okay, we're going to go ahead and resume the hearing. So before the recess, I wanted to see if either judges had any questions or comments.
I have none.
None.
Okay. All right. We'll take a final statement from Mr. Wilson. Mr. Wilson? Mm-hmm.
Your Honor, the Tennessee Constitution in Article 2, Section 13 provides for both legislative independence and also separation of powers to prevent the co-equal branches from coming into the legislative process and requiring legislators or their aides to disclose documents that are integral to the legislative process and the formulation, proposal, or enactment of legislation. And to prevent, and also to prevent the legislators from having to respond to discovery requests and litigation requests. I mean, but by an analogy, it would be unheard of for the legislature to say, you know, we want to dive into a judge's notes or internal reasonings behind going into a decision that was made. And so those are the same separation of powers concerns that also animate the constitutional enshrinement of the speech or debate protections. And for those reasons, we request that that this panel grant the Office of Legal Services motion to quash and for a protective order.
All right. Thank you, Mr. Wilson. And Mr. Peterson.
Your Honors, plaintiff submits that the case law in the speech and debate clause of the U.S. Constitution does not support a non-disclosure privilege. As noted earlier, no Tennessee court has ever adopted that position, and the majority of the U.S. Court of Appeals, most recently the Ninth Circuit, and plaintiff would direct the panel to the Renzi decision, analyzed the majority of the cases upon which OLS relies and rejected that there's this rationale underpinning the speech or debate clause about interference with legislators' duties, and that judges can even oversee the disclosure of documents to a party when those documents won't even be used against the legislatures in the end run. But Your Honors, even if this panel is not convinced that the speech or debate clause provides no non-disclosure privilege, ultimately the panel should deny OLS's motion on the basis that the blanket assertion of privilege is insufficient. OLS has provided the panel with no real ability to analyze whether their privilege should be applied to an unknown universe of documents. So in sum, we request the denial of the motion. Thank you very much.
All right, thank you. And let me give Mr. Wilson one final reply, since it's his motion.
Your Honor, thank you, Your Honor. Again, just to my friend's last point, the only evidence in this case is that the Office of Legal Services operates within the legislative sphere that the speech or debate clause protects. There's no evidence that the Office of Legal Services is operating outside of that. We've got the declarations in the record from the directors. We've got also the statutory duties as well. There's nothing here on this record to show that the Office of Legal Services is acting beyond the sphere when all of the evidence and the statutory record shows that the Office of Legal Services is operating to help aid General Assembly members in the discharge of their official legislative functions in the formulation, proposal, and enactment of legislation. Thank you, Your Honors.
All righty. All right, attorneys, thank you so very much for appearing this morning, and the arguments have been very zealous on both sides, and we were going to take up a scheduling order, but given the fact that we've gone a couple hours and the decision the court makes may affect what scheduling orders in place, what I'm going to recommend is that we come back. We set a date to come back and deal with the scheduling order, but let us take these two motions under advisement. Let the judges review it, and then once the panel is ready to issue a ruling, we will do so expeditiously, because I know that time is moving and time is of the essence, and we want to keep this case on track. But once we get that order out on the motions, we will be in contact with you, and we'll try to reconvene to take up the scheduling order. Judge Tidwell, Judge Cook, does that sound like a plan?
It does.
Okay.
Yes.
All right. All right. Very good. Well, then that's what we'll do then. So if there's no further comments, we're going to stand in recess. You gentlemen have a great afternoon. We want to thank the public, those of you who have been on the stream with us, for participating in the hearing, and we wish everyone a great afternoon and everyone be safe. We'll stand in recess.
Thank you, Your Honor.
All right, thank you. Mm-hmm.
So right. Judge Well and Judge Corbin Johnson, are we going to talk